When people think about cybersecurity, they think about hackers and ransomware. They rarely think about the data they voluntarily hand over every day to apps, platforms, and services they trust. This module covers what personal data actually is, how it flows without you noticing, what your legal rights are under GDPR, and most importantly, the connection between privacy and security that most people miss entirely. Privacy protection is threat reduction. Every piece of data an attacker doesn't have is a spear phishing email they can't write convincingly. In 2010, a technology investor made an observation that has since become one of the defining phrases of the digital age. If you're not paying for the product, you are the product. It is a simplification, but a useful one. Every major free digital service, search engines, social media platforms, email, maps, video streaming is built on a business model that monetizes your attention and your data. The service is free because the real transaction is not happening between you and the platform. It is happening between the platform and advertisers, who pay for access to detailed profiles of people's interests, habits, and vulnerabilities. This is not inherently sinister. People make conscious trade-offs. Free email in exchange for some data collection is a bargain many people find acceptable. The problem is when the trade-off is not transparent, when the data is used in ways people did not expect, or when the accumulated profile becomes a tool for manipulation, discrimination, or exploitation. Personal data under GDPR is defined as any information relating to an identified or identifiable natural person. That definition is deliberately broad, and it covers far more than most people think of as personal data. Basic identifiers: your name, date of birth, address, phone number, email, enough to impersonate you, open accounts in your name, or pass security questions. Financial data: bank accounts, payment cards, credit scores, a direct pathway to fraud. Special category data: health records, racial or ethnic origin, political opinions, religious beliefs, biometric data, sexual orientation. These receive the highest protection under GDPR because misuse can cause discrimination, harm, or persecution. Behavioral data: browsing history, search queries, location history, purchase patterns, app usage, reveals your habits, relationships, vulnerabilities, and preferences. This is the most commercially valuable category for profiling. Communications data, email content, message history, call logs can be used for blackmail, social engineering, or professional harm. Device and technical data, IP addresses, device identifiers, browser type, cookie identifiers, used to track you across websites and build profiles even without knowing your name. Now the aggregation problem, and this is worth understanding clearly. Your first name, harmless. Your employer, harmless. Your approximate neighborhood, harmless. The coffee shop you visit every morning at 8, harmless. Combined, those 4 pieces of information create a profile precise enough to physically locate you at a specific time and place. This is the aggregation problem. The harm is not in any single piece of data. It is in what emerges when they are combined. It is why data minimization matters even for data that individually seems trivial. Most people have a vague sense that companies collect data about them. Fewer understand the specific mechanisms. Understanding them makes you a more conscious participant. Cookies and tracking. A cookie is a small file stored on your device by a website, allowing the site to recognize you on future visits. That is useful. It is why your shopping cart persists when you come back. Tracking cookies go further. Placed by third-party advertising networks, they follow you across multiple websites, building a profile of your browsing behavior across the internet. Not just what you do on one site, but the pattern of what you do everywhere. When you click Accept all cookies without reading the options, you are typically consenting to this cross-site tracking. The Reject All option, which EU law requires to be as easy to find as Accept All, though many sites bury it deliberately, reduces it significantly. Tracking pixels. A tracking pixel is an invisible image, sometimes a single transparent pixel, embedded in a web page or email. When it loads, it reports back to the sender. You open this email at this time on this device, in this approximate location. Every marketing email with an open rate statistic is using tracking pixels to measure whether you read it. You can reduce their effectiveness by disabling automatic image loading in your email client. Data brokers. Data brokers are companies whose entire business model is collecting, aggregating, and selling personal data. They gather information from public records, social media, purchase histories, app data, voter registers, and hundreds of other sources. They combine these into detailed profiles and sell them to marketers, insurance companies, employers, lenders, and increasingly to anyone willing to pay. You almost certainly have a profile with multiple data brokers, even if you have never heard of them. EU residents have the right under GDPR to request deletion of their data from data brokers. Exercising this right is time-consuming. There are hundreds of brokers, but services exist that automate the process for a subscription fee. If data privacy is a priority for you, they are worth considering. App permissions are the third mechanism most people underestimate. We covered this in Module 10 in the context of access control, but the privacy dimension is just as important. A flashlight app that requests access to your contacts is not serving you better. It is harvesting your address book. A free game that wants your location at all times is not improving gameplay. It is selling location data. Reviewing and revoking unnecessary app permissions is one of the most direct ways to reduce data collection from your phone. The General Data Protection Regulation is EU law that gives you specific, concrete rights over your personal data and places obligations on organizations that collect and process it. You do not need to be a lawyer to use these rights. You just need to know they exist and how to invoke them. Right to be informed, organizations must tell you what data they collect, why, how long they keep it, and who they share it with, usually in a privacy notice. Read the privacy notice before signing up to a service that will hold sensitive data about you. Right of access. You can request a copy of all personal data an organization holds about you. This is called a Subject Access Request, or SAR. The organization must respond within 1 month, usually free of charge. When is a SAR useful? When you want to know what a company holds about you before making a significant decision. When you suspect data about you is inaccurate. When you are involved in a dispute. Employment, insurance, financial, and need to understand what information the other party has. To make a SAR, send an email to the organization's data protection officer or privacy contact. State that you are making a subject access request under GDPR Article 15 and describe what you are looking for. They must respond within 1 month. Right to rectification. You can ask an organization to correct inaccurate personal data they hold about you. Particularly important for credit reference agencies, insurance companies, and healthcare providers, where inaccurate data can directly affect decisions made about you. Right to erasure, sometimes called the right to be forgotten. In certain circumstances, you can ask an organization to delete your personal data. This applies when the data is no longer needed, when you withdraw consent, or when the processing was unlawful. It is not absolute. Some organizations have legitimate reasons to retain data, such as legal obligations. Right to data portability. You can request your personal data in a machine-readable format to transfer to another service. Useful when switching banks, email providers, or social media platforms. Request your data export from account settings. Right to object. You can object to your data being used for direct marketing, profiling, or certain automated decision-making. Unsubscribing from marketing lists is the most familiar expression of this right. One practical note. If an organization ignores a valid rights request or makes it unreasonably difficult to exercise your rights, you can report them to your National Data Protection Authority. In Poland, that is the UODO. In Germany, the BFDI. In Ireland, the DPC. In the UK, the ICO. G. GDPR's data minimization principle, collect only what you need, applies to organizations by law, but it is equally useful as a personal habit. Data you do not share cannot be collected, breached, or misused. When signing up for services, when a service asks for your date of birth, consider whether it needs your actual date of birth or just confirmation that you are over a certain age. When it asks for your home address for a digital product, question whether that is actually required. When a newsletter asks for your phone number, ask yourself why a newsletter needs your phone number. Providing minimum necessary information and being willing to provide placeholder information for optional fields that are not legally required and not essential to the service reduces your data footprint. Aliases and secondary identities. Many privacy-conscious people maintain a separate email address for services they trust less. If one address is breached or sold, the impact is contained. Apple's Hide My Email and services like Simple Login let you generate unique email aliases that forward to your real inbox, so you can delete an alias the moment it starts receiving spam, without affecting your primary address. Social media audit. Your employer, your location, your daily routine, your family members, your pet's name, your car, your home's exterior, all potentially visible to anyone, including attackers researching spear phishing targets. Review your public profile settings periodically. Reduce what is visible to friends or connections only for anything that could be used to locate you or impersonate you. Practical settings to change. In Google, go to myaccount.google.com, data and privacy, and review history settings and add personalization. On iPhone, settings, privacy, and security, and review each app's permissions and app tracking transparency. On Android, settings, privacy, permission manager. In your browser, look for tracking protection settings and consider Firefox in strict mode or enabling HTTPS only mode. And finally, the connection that completes this module. Privacy and security are sometimes treated as separate concerns. They are not. Every piece of personal data you share increases your attack surface. The location data your phone shares with apps can be used to determine your home address, your workplace, your daily routine, and when you are away from home. The social media profile that shows your employer, your colleagues' names, and your recent travel creates the raw material for a spear phishing attack that would fool almost anyone. The data broker profile that shows your interests, your financial situation, and your relationships gives an attacker leverage for social engineering. Privacy protection is threat reduction. Limiting data collection does not just protect your personal autonomy, it directly reduces the quality of information available to people who want to attack, defraud, or manipulate you. The fewer accurate data points an attacker has, the less convincing their impersonation, the less targeted their approach, the more likely their attempt fails. Alright, before we move on, here are the 3 things from this module I want you to hold on to. Number 1. Personal data is far broader than most people think, including behavioral data, location history, and device identifiers. None of it is truly trivial. Number 2. The aggregation problem. Individually harmless data points combined into profiles precise enough to physically locate you. Number 3. Privacy is security. Every data point you share increases your attack surface. Less data available equals less convincing attack. Now, before you move on, there is one question. A fitness app asks for permission to access your contacts, location at all times, microphone, and camera to track your runs and log workouts. Which permission should you grant? The correct answer is B. Apply the permission test. For what this app does, why would it need this? A run tracking app needs location. That is its core function. It may need camera for logging photos. It has no plausible reason to need your contacts or microphone. A contact permission on a fitness app is a red flag. The app is likely harvesting your address book for commercial purposes. If you cannot construct a plausible reason for a permission, deny it or choose a different app. Next up, Module 14, Trusting Third Parties. See you there.